Hey there, everybody, this is Jesse Weber with a special report. We are planning on jumping live in a few minutes into the first court appearance for Chad Daybell. This is the husband of Lori Vallow Daybell, who's been charged in connection with the disappearance of her two kids, JJ and Tylee, who have been missing since September. Now, we know that Chad Daybell yesterday was arrested and charged with 2 counts of destruction, alteration, or concealment of evidence. This comes after authorities found on his property 2 sets of human remains. Now, at this point, the identities of the remains are unknown. Autopsies are pending. However, we heard from the Rexburg mayor out in Idaho that he said or seemed to suggest that these bodies were in fact the kids. Now, before we jump live into his first court appearance, I'm here with Law&Crime's own Terry Austin. Terry, this has been quite the development, especially that we have learned that there are 2 sets of human remains. What are your thoughts at this point?
Jesse, there's no question in my mind that the fact they found 2 sets of remains means to me that JJ and Tylee are definitely those remains. Obviously, we have to wait to hear, but it does seem like that's the distinct possibility.
Okay, so you have to tell me, and because authorities are keeping this very, very close to the chest here, what led them, or what do you think led them to his property? We don't know this at this point unless you've heard something, and we do have our very own Kathy Russin, our executive trial producer, who's at the scene, and she's going to be reporting back to us later on today on my 5 o'clock show. But the question, of course, is what do you think led authorities to his property?
I think, Jesse, when they went to his property earlier this year, they saw information and they've been culling through that information since then. I think they went back and they decided to look over the rest of the property and they found these remains. So they've been at it since the very beginning.
Why won't they tell us what happened here? We know it was this coordinated effort between the sheriff's office, the police department, the FBI. We're still not clear what led to this warrant. We were looking at aerial photos of the property, being exhumed and trying to see what was found and what they were looking for in the yard. But again, we don't know. Is there a possibility Lori may have said something during her time that led authorities to Chad?
Well, we see that often where you're in prison and you're talking to your prison mates and information gets out. So that's a distinct possibility too, Jesse. I think that the authorities are trying to get their story together. And before they come out with a press conference or make any further statements, they want to make sure that they have the information correct. So I think that's part of the issue as well.
He faces now, and what this hearing is going to be about, is destruction, alteration, or concealment of evidence. These are 2 felonies, punishable up to 5 years in prison each. The fact that he was charged with this and the fact that perhaps he could be charged with something down the road. Your thoughts on these charges?
Well, right now, this is all they have. They haven't identified the bodies. They found these remains, so they can't charge him right now with any sort of murder charge. But I do think once the remains are identified and positively identified as the children, we'll see charges against Chad and we'll see charges against Lori as well. I think right now, since they've asked him about the children, he denied knowing where they were. These are the charges that they can bring against him at this point.
But whoever this is, whoever the remains are, why didn't they charge him with murder at this point? I mean, they don't have enough evidence to tie him to the killing of whoever these people are. Only they say, and I want to quote directly from the criminal complaint, that he willfully concealed and or did aid or abet another to willfully conceal human remains. So the fact that those remains are on his property doesn't necessarily mean at this point that he is involved in how these people ended up dead, correct?
That's exactly right, Jesse. It could very well be that Lori Vallow killed the children and he's an accessory after the fact and he helped her to dispose of the bodies. We'll have to see what the evidence says, but I think right now they're holding off until they know more specifically. Clearly, they need to know who these remains are.
All right, and if you're just joining us, we're waiting to jump live into Chad Daybell's first court appearance with the COVID-19 restrictions. It's going to look a lot different. For one, a lot of it's going to be remote. I believe the prosecutor won't even be there. But I'll tell you what, before we jump into what we can expect as we go live, I want to turn to the press conference yesterday where these new developments were announced. And I got to tell you, this came out of nowhere because we were waiting to see if there would be a development in the Lori Vallow Daybell saga, if we would have a development about what happened to these kids. Sadly, at this point, we are all thinking the worst, and clearly the mayor is assuming the worst. But let's go to this press conference from yesterday.
So today, the Rexburg Police Department, as well as the Fremont County Sheriff's Department and the FBI conducted a search warrant in the 200 block of North 1900 East in Fremont County. It's also the residence of Chad Daybell, that's a Fremont County resident. During the search of the property, investigators discovered what appeared to be unidentified human remains, and an autopsy will be conducted. Shortly after the remains were discovered, Chad Daybell was taken into custody and booked into the Fremont County Jail.
All right, so that's where we are right now. Terry, we're waiting to jump live into this hearing. Now, aside from the fact that a lot of this is going to be remote, I believe it's only going to be the judge and the clerk in the courtroom. What are you expecting? What are you expecting to hear today? How long will this be? What are you going to look out for?
Well, I think it's going to be relatively short. I mean, this is a hearing, and oftentimes these hearings don't have much content. I think that they'll make clear what the charges are. I'm assuming his attorney is going to be there, in which case they'll maybe plead that he's not guilty of these particular charges. But I think with COVID-19, we're not going to be able to get an inside scoop and be inside the courtroom. But I don't think that it's going to be a very substantive day today.
Are you waiting to hear this hearing, and then perhaps we're going to hear more information from authorities? Are they restricted in some way from not saying anything until his first court appearance? In other words, after the court appearance, do you expect to hear anything?
I do think we're going to hear more after the court appearance. They could come out and say much more than they already have. I think they're being very careful, and I think that's the wise move to make. You don't want to tip your hat. You don't want to say more than you have already as far as the evidence is concerned. So they're waiting for the hearing. They're waiting to see exactly what the charges are, and then I think they'll come out and make more definitive statements after that.
So people might be looking at this and saying, wow, if these are in fact the kids and the remains were found on his property, how come authorities didn't find these remains earlier on? You know, why did it take so long? It wasn't as if they were found in another state. It wasn't as found in a garage. I mean, literally found on his property. So what do you say to people who are wondering, well, you should have looked there at the beginning months ago, or could they not have looked months ago?
You know what's interesting about this? It was months ago, but at least it wasn't years ago. For whatever reason, these investigations take a lot of time. We see sometimes that charges aren't brought until years after the fact. So here we have it months after the fact. The children disappeared in September. Here we are in June. We had COVID-19. So I think what I would say to viewers and to the community, generally speaking, this is pretty fast. And, you know, I have to think about the fact that the weather probably played a part in this as well.
That's a good point. And I want to ask you about this. Is there a possibility of a defense at this point? Okay, I'm getting word. We'll talk about it after. We can go live into court. Let's go.
All right, we're going to call up the case. One moment. We're going to go on the record. Good morning here in Fremont County, Idaho. This is the case of CR 2220-755, State of Idaho versus Chad Guy Daybell. This matter is being held at the Fremont County courtroom via Zoom remotely. Mr. Daybell, the defendant, appears with his counsel, Mr. Pryor, at the jail here in Fremont County. Mr. Wood appears remotely from his office. There is the clerk here, there's a court reporter, and there is some IT support that is also on the line. This is the date and time set for an initial appearance. The reason we're holding this hearing remotely via Zoom is due to a order that's been issued by the Supreme Court. In that order, it designates that whenever plausible, hearings are to be held remotely in order to effectuate safety of society and effectuate safety of all employees in the courtroom. In future proceedings, it will be an issue that's addressed case by case and hearing by hearing. That order is dated April 22nd, 2020, and has been issued by the Idaho Supreme Court. Mr. Daybell, do you read, speak, and understand the English language?
Yes.
Mr. Daybell, can you hear me okay today?
Yes.
Mr. Daybell, it appears that you have hired private counsel, Mr. John Pryor, is that correct?
Yes.
And you'd like to retain him. Mr. Pryor, has there been a formal notice of appearance that has been entered?
Judge, I will get that filed within a short period of time.
All right, but Mr. Daybell, Mr. Pryor is your attorney for this hearing, is that correct?
Yes.
Mr. Daybell, have you seen a notification of rights form that was provided to your counsel prior to the hearing here today?
Yes.
Do you understand all of your legal rights?
Yes.
Mr. Daybell, in addition to the rights that were contained in that notification of rights form that was given to you, I'm going to advise you of additional rights under Idaho Criminal Rule 5. Number one, you have the right to be at the initial appearance or appear via Zoom remotely like you are today. You don't need to make any statements today. You have the right to know what charges are being brought against you. You have the right to bail. You have the right to counsel. And you have all of the other rights that have been presented to you in that notification of rights. Do you have any questions about your rights, Mr. Daybell? I didn't hear your answer.
No, he does not.
You understand your legal rights, is that correct?
I do.
All right. Mr. Daybell, did you receive a copy of the warrant of arrest as well as the criminal complaint that has been filed here in Fremont County in this case?
Yes.
Mr. Daybell, have you had a chance to review that criminal complaint as well as the arrest warrant with your counsel?
Yes.
Mr. Pryor, I can read the criminal complaint in its entirety, or I can summarize it for you.
Judge, we'll waive actually formal reading of the criminal complaint at this time, and I've discussed that matter with Mr. Daybell, and we're ready to proceed forward without either a summary or a formal reading at this point, Your Honor.
All right. The court is going to summarize briefly what the charges are, so that that's on the record, and then we'll address the other issues we need to address. Let me get one more thing out of the way, Mr. Pryor. Ultimately, the Supreme Court order has ordered these hearings be held remotely, but it's my understanding your client is willing to waive his right to be here in court in person. Is that correct?
It is, Your Honor. Thank you.
Okay. Mr. Daybell, is that also correct?
Yes.
With regards to the criminal complaint, it was filed dated June 10th, 2020. There are 2 counts in the criminal complaint. The first count is destruction, alteration, or concealment of evidence, a felony, a violation of Idaho Code 182603. The maximum punishment for that charge is up to 5 years in the state penitentiary and or up to a $10,000 fine. The allegation is that the defendant, Chad Guy Daybell, on or between the 22nd day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully conceal and or aid and abet another to willfully conceal human remains, knowing that said human remains were about to be produced, used, and or discovered as evidence in a felony proceeding, inquiry and or investigation authorized by law with the intent to prevent it from being so produced, used, and or discovered. Count 2 is also the same charge, destruction, alteration, or concealment of evidence, a felony. It's punishable by up to 5 years in the state penitentiary and or up to a $10,000 fine. It alleges that the defendant, Chad Guy Daybell, on or between the 8th day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully destroy, alter, and or conceal human remains, and or did aid and abet another to willfully destroy, alter, and or conceal human remains, knowing that said human remains were about to be produced, used, and or discovered as evidence in a felony proceeding. Inquiry and or investigation authorized by law with the intent to prevent it from being so produced, used, and or discovered. Mr. Daybell, do you understand the allegations on both counts that have been brought against you?
I do.
Mr. Daybell, do you also understand the maximum penalties on each of those counts?
Yes.
Mr. Daybell, do you understand that those maximum penalties could run consecutively, one after the other, or they could run concurrently? Do you understand that?
Yes.
All right. We've gone through the criminal complaint. We've gone through each count. I've advised the defendant of his right. We've gone through that form. Let's discuss the next hearing that's going to be set. Mr. Pryor and Mr. Wood, that next hearing would be a preliminary hearing or a probable cause hearing. The defendant has a right to have that within 14 days if he's incarcerated. It's my understanding that based upon previous conversations that there'll be a waiver of that speedy preliminary hearing. Is that correct, Mr. Pryor?
It is, Your Honor. I've had that discussion with Mr. Daybell. In addition, I've had that discussion with Fremont County prosecuting attorney, and at this point, we'll waive the time.
Mr. Wood, is that correct as far as the stipulation?
Yes, the state's fine with that, Your Honor.
Mr. Pryor, the court's going to grant that waiver and acknowledge that it's knowingly and voluntarily made, but I will need a written waiver of speedy preliminary hearing so that can be in the file for the record. Do you understand?
Yes, Your Honor. I'll do that. Thank you.
All right. With regards to a preliminary hearing, let's first talk about the logistics of that. Mr. Wood, how long do you foresee it taking to accomplish a preliminary hearing in the future?
No longer than a day.
Okay. 1 day. Mr. Pryor, do you concur with that?
Judge, I'm at a little bit of a disadvantage, but for practical purposes, I think a day would be appropriate.
All right. We'll set this for 1 day. Mr. Wood and Mr. Pryor, do you have a timeline that you'd like to look at as far as scheduling that today?
Judge, my preference would be within 4 to 6 weeks.
Mr. Wood?
That's fine. We do have a preliminary hearing on July 9th and 10th in the Lori Vallow case. And so if we are going to push it out that far, I'd ask that this prelim be at least the week of the July 16th.
Unfortunately, I'm going to be out of town the week of July 16th, and I won't be back for some time. So if we need to have it in July, it probably needs to be towards the beginning of July or into June. Otherwise, it's going to have to be the last week of July. Mr. Pryor, does that work with your schedule?
Judge, the latter part of June and the first week of July, the 1st and the 2nd of July would be ideal for me if that's available to the court and to Mr. Wood.
We can
Mr.
make
Wood?
that work.
All right, let's look at dates then. I'm looking at the calendar. The end of June, it looks like those Monday is the 29th, and then Tuesday is the 30th. And then Wednesday is July 1st, Thursday, July 2nd. Which of those days do both of you prefer?
I think the second would be best for the state.
Mr. Pryor, does that work for you?
Judge, I believe the second falls on a Friday, if I'm not mistaken. So I would like to see if we could do the first, and if necessary, we can have the second available in the event this thing runs a little longer, Your Honor.
Okay, so the second is a Thursday, Mr. Pryor, but I appreciate that you would like to have extra time if it does go over. So if we set it for the first, Mr. Wood, can we do that? And then if it spills over into the second, we'll make sure that date's available.
That'd be fine.
Okay. We'll set that then July 1st and July 2nd for the preliminary hearing or the probable cause hearing. Lastly, the court has issued the arrest warrant. The court designated that it would address bond and or bail at the hearing set today. And so I'd like to hear argument from both parties regarding bail. So why don't I hear from the state first, and then I'll hear from the defense.
Thank you, Your Honor. The state is requesting that bail be set at $1 million. While we recognize that felony concealing of evidence only has a maximum sentence of 5 years per charge, I think the background and context of this case necessitates a higher bail. One of the primary reasons we are asking that bail be set in that amount is that the evidence that has been concealed in this case, it's not simply a document, drugs, a gun. These are human remains. And we can, although those remains have not yet been positively identified, we are aware that those remains are the remains of children, which we believe is an aggravating factor. We have asked that the probable cause affidavit be sealed, but I would ask the court to take note of paragraphs 39 and 40 and the manner of the concealment of one of those bodies, which the state finds to be particularly egregious, both an aggravating factor and bears on character, as Rule 40 as Rule 46 allows us to look at. Your Honor, we understand that the possible sentence on this case is not that long, but knowing what the subject matter is, we find it extremely serious. And we would also note that because of what has been found on Mr. Daybell's property, should he bail out, he has strong incentive to flee. Clearly, this is the beginning now of an investigation into the deaths of children who are found on his property. And so that provides a strong incentive to flee, and we would ask that the bail reflect that. Whatever the court sets as bail, we would ask that the conditions be set that should he bond out, that he be required to wear an ankle monitor, and that his movement be restricted to Madison and Fremont counties.
Thank you, Mr. Wood. Mr. Pryor, I'll hear from you next.
And Judge, just for purposes of the record, my understanding is the court's allowing us to address this issue of bond, but that in no way limits us in the future to file a further motion for bond if that's necessary. And I believe that's the court's understanding, Mr. Wood's understanding as well, is it not, Judge?
Let me make that clear for the record. Because of the nature of timing and such, generally speaking, the court sets a bail based upon a probable cause affidavit, and then if a motion needs to be filed after, it can be filed. I did not set a bail because, frankly, it was timing. And so, correct, Mr. Pryor, I'm going to give you complete ability to file a renewed motion or a first motion to deal with bail. I guess de novo is how you could look at that. And so I'm going to set bail today. When you file your motion, the court will definitely give you a hearing for that, and we'll take it and make a decision based upon that.
Thank you, Your Honor. But in regards to argument, Your Honor, I would point out that the charges are, as Ms. Ward pointed out, carry a maximum of 5 years. Mr. Daybell is not charged with anything more serious. And quite honestly, for the prosecuting attorney to assume that in the future he may or may not do that, and that we should increase the bail with the idea that in the future there may be something else coming down the pipe is just clearly contrary to what the purpose of bail is. Bail is to assure that Mr. Daybell shows up to court. Bail is to assure that he's not a flight risk, and there's nothing, in, as far as I'm concerned, in his history that indicates that he's going to flee the jurisdiction. I would refer the court to the affidavit on number 26, and it talks about the last time that they saw the kids. If Mr. Wood's intention is to pursue further charges, my belief is that he would have pursued those. And quite honestly, at this point, the court needs to take consideration of what the current charges are and whether or not Mr. Daybell will show up to court. Mr. Daybell has taken the initiative to hire private counsel. He has shown up to the proceeding today. Obviously, he's in custody. But Judge, when the police showed up at his house last night, Mr. Daybell didn't flee. Mr. Daybell didn't abscond. Mr. Daybell didn't run. Mr. Daybell's intention was, through his counsel, to turn himself into the court if that was something that was going to happen and address these issues. He has every intention of addressing these issues. He has significant family in the community. He has kids that live here. He owns property here. And quite honestly, I disagree with Mr. Wood. Mr. Daybell has every intention of staying in the community and every motivation to stay in the community and address these charges. So at this point, Judge, I would ask the court to put the bail at an amount that's appropriate for a 5-year felony sentence. I understand that there's been a significant amount of publicity with this, but publicity is not a reason to raise the bail to an extraordinary amount. And I would suggest that Mr. Wood's suggestion that a $1 million bail is okay, it's not okay, Judge. A $1 million bail is not okay for a 5-year felony sentence. And if in the future Mr. Wood decides to pursue other charges, I'm sure we'll address this again. But at this point, Your Honor, I think it's important for the court to set a bail at an appropriate amount based on the 2 felony 5-year sentences. I would ask the court for $50,000 on each count for a total of $100,000, Your Honor.
Thank you, Mr. Pryor. The court has listened carefully to the argument of both parties. The court has reviewed Idaho Criminal Rule 46, specifically the factors contained in Idaho Criminal Rule 46 under subsection C. There are 10 different factors that the court has looked at. The court has also looked carefully at Idaho Code 192904 and the factors that are designed therein. In looking at the factors in 192904, there are 4 specifically that the legislators have set forth. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court is cognizant that there is an absolute constitutional right to bail provided in both the Idaho Constitution and the U.S. Constitution. The court has taken all of those factors into account, and based upon those factors and the charge, the court is going to set bail in the amount of $1 million. The court notes that the charge is destruction, alteration, and concealment of evidence as pertained in the criminal complaint. I've taken all those factors into account. Specifically, the factor in Rule 46C, subsection 6, which designates I'm to take into account the nature of the current charge and any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. The underlying charge here is destruction, alteration, and concealment of evidence, and the allegation is that the evidence was human remains of 2 different people. That's an aggravating factor, and the court has taken that into account. If bail is posted, Mr. Pryor, I'm also going to make conditions of bail. Those conditions will be as follows. Number 1, I'm going to order that a waiver of extradition be provided to the Fremont County Office of the Sheriff. The prosecutor must approve the waiver of extradition by his signature on the waiver of extradition. A copy of that waiver must be filed with the court. Number two, I'm going to order that the defendant shall reside within the boundaries of Bonneville, Jefferson, Madison, and Fremont counties in the state of Idaho. The defendant shall not leave these counties for any reason. Number three, the defendant shall provide the court with his current address and shall not change his address without notifying the court. Number four, the defendant shall keep in regular contact with his attorney. Number five, the defendant shall appear for all court appearances. Number six, the defendant shall obey all laws of the state of Idaho and the United States of America. Number seven, the defendant will sign up for pretrial services and check in with pretrial services here in Fremont County on a weekly basis, as directed. The defendant shall have absolutely no contact with the victims' families and or any of the state's witnesses in this case. Contact shall include, but be not limited to, verbal contact, written contact, visual contact, text messaging contact, email or internet contact, and or telephonic contact. Such contact shall also include contact through third parties. Number nine, the defendant must wear an ankle monitor 24 hours a day, 7 days a week. He must have the ankle monitor in place before he is released from the Fremont County Jail. Any violations of the geographical limitation imposed herein must be reported immediately to the Fremont County Sheriff's Office and the court. If the defendant is notified that under the order to wear the ankle monitor, intentionally leaving the area of restriction, except for the purpose of obtaining emergency medical care, may be prosecuted as a crime of escape and subject the defendant to penalties under Idaho Code. If the defendant fails to comply with all of these terms, the court may, pursuant to Idaho Criminal Rule 46I and Idaho Code Section 2919, revoke the defendant's release and eligibility for posting of bail. Mr. Daybell, Mr. Pryor, do both of you understand what bail has been set at, as well as any conditions that must be met in order for that bail to be set?
Yes, Your Honor. Yes.
Mr. Wood, any questions?
No, thank you, Your Honor.
All right, we'll be in recess for today, pending that preliminary hearing. There will be a few things that need to be worked out, and we're going to go off the record for now, and I'll see everybody back here at the beginning of July. Council will have to communicate regularly, both with the court and with each other, about how this hearing is going to be held, whether it's going to be held remotely or whether it's going to be held in person. Mr. Wood or Mr. Pryor, do either of you wish to address that issue today?
Not today, Judge.
No, and I can, Mr. Pryor and I can visit and talk about that and see if we can come to an arrangement before we address that issue with the court.
All right, I will just state for the record that the court will need to make findings if we're going to do it live in person, and we'll address that at a future hearing on whether or not that's going to take place. With that, we'll be in recess. Thanks, everybody, for appearing.
Okay, some major developments that we learned today during Chad Daybell's initial court appearance. So bail has been set at $1 million, and between July 1st and July 2nd is when we're going to have that preliminary hearing. I'm back here with Terry Austin. Mostly procedural, but let's start with the $1 million bail. As you heard, the defense attorney there, John Pryor, who is now representing Chad Daybell, he said, listen, these are crimes that carry 5 years imprisonment. You're assuming the worst. You're assuming there are going to be more charges down the road. At this point, it should be only in the range of, I believe he said $200,000, maybe $250,000. And yet the judge set it at $1 million. Your thoughts, Terry?
I think that was the right decision. The judge looked at the fact that the nature of this crime is so heinous that if in fact these remains are the children, they are remains of a human being, then even though the penalty is only 5 years, the judge is thinking this is really a heinous crime, $1 million. And I think in the back of his mind, he's also thinking about the fact that Lori Vallow's bail is also set at $1 million. And so I think it makes complete and total sense. Plus the fact that he hid these remains. So, you know, who knows what else he'll do to try to avoid being charged and being tried and being convicted.
Not just remains. We heard from prosecutor Rob Wood. He said children's remains. And Terry, you heard that. Children's remains. He said, obviously, we have to positively identify who the remains belong to, but clearly indicating that it was probably Tylee and JJ. That's a big revelation there. I know the authorities have been tight-lipped. What did you make of that?
Well, I think that there's no doubt in anyone's mind that once the information comes back and all the forensics have been completed, that it will be JJ and Tylee. Who else could it possibly be? The fact that there remains on his property is in and of itself disturbing. And I think the judge in the back of his mind setting the $1 million bail was thinking also, look, both Lori and Chad, they've been in Idaho, Arizona, Hawaii. They could flee. He could flee. So I think it's the right amount.
Yeah, that's a big point considering their history and what could the resources they might have to ultimately leave. You heard the defense say, well, he has his property here, he's got family here, he's not going to really flee. But clearly the judge didn't believe in that. Now, we got a long time between right now and that preliminary hearing. What usually happens during this time? What could we expect at a preliminary hearing?
Well, I think July 1 and July 2 are going to get here very quickly. Time is passing fast. And I think what the investigators want to do and what the authorities need to do is get their ducks in a row. They're going to hopefully have the forensics back by then. And if not, they're going to have more information, I think, to shed on these charges. And I think at the probable cause hearing, we're going to make sure that these are indeed the right charges that should be filed against Chad. And so, you know, we'll see what happens. But I think they're going to be working very hard between now and then.
In other words, you're saying we might see more charges down the road between now and the preliminary hearing. You know what was interesting? I caught very, very short responses from Chad Daybell. We didn't expect much from him. But when we deal with a case, when we're talking about religious motivations and these kind of crazy thoughts and crazy motivations, he did understand his rights. He's represented by counsel. He appeared to be compliant. He appeared to be coherent. You know, we're talking about what are potential ways this might go. Mental health defenses. We talked the other day, Lori Vallow's attorney wouldn't even indicate if mental health is going to be an issue in her case. Did that strike you at all, his behavior today, whether he seems out of it? He seemed to understand his rights, and that's a big step for the prosecution.
I have mixed feelings about his behavior today. You're 100% right. He seemed to understand all of his rights. He waived his appearances, frankly, at the hearings. But I think that he was a little more subdued. He wasn't as confident as we've seen him in the press. So I think that he was
just hit with these two charges that carry significant prison time if they were the maximum charges and to run one after the other. Terry, this has been a really interesting day. I know you're going to be back with me tonight at 5 o'clock. We're going to be breaking this down. We're going to have Kathy Russin on, who's at that scene. She's in Idaho. She's going to be reporting back to us. So stay tuned. Tune in again at 5 o'clock tonight for Law and Crime Now. As of now, we're going to turn back to our regularly scheduled programming.
We're going to take you to a quick break, and then we'll be back live in that courtroom.
If you're over 50, did you know you could be taking advantage of everything AARP has to offer right now? Join today for just $12. Find out what 37 million AARP members already know. Benefits start instantly.
It's AARP.
Are you joining AARP?
Actually, I just did.
But is it worth it?
Well, I enrolled at 7:02, saved on concert tickets at 8:10, read a great article on investing at 9, found a sweet travel deal at 10:15. I used the caregiver finder for my dad, and done. Discounted movie tickets.
Call or go to